I gather he's a great deacon in the Central Kingston. Presbyterian.
Yes. Let us pray. Dear Father, as we gather to review and contemplate the provisions of this bill, we invite thy holy presence and thy guiding hand. We pray that our minds will be inspired so that at the end of the day, we will have a just bill. In Jesus' name we pray. Amen.
Thank you. All right. This morning I said right. I'm going to ask Minister Ford to lead us through as we go through, but the Firearms Act is one of the pieces of legislation we consider critical now to get through. We had delayed 2 weeks to get submissions. We haven't had too many, quite frankly. I think I don't know if it's the time that was given. We have had 2 submissions, one that is quite crude. The other one I think we won't take them at this stage. We're going to go through the bill and we'll circulate the submission we have that is available and then decide how to approach them. The Bar Association has asked us to give a little more time. Of course, given the nature of the bill and the profession involved, we have to first accede to we give them some time. And again, the JSCF has some comments to make as well, which will come a little bit later. I have an apology from Senator Peter Bunting, I accept, but I'm sure he is. Senator Motley will do very well representing the entire team, very well. So welcome and thank you. So, Minister Ford, you want us to start the process? We have all day bear in mind. I don't know him. I should ask how we should ask Ms. Anila to make we have somebody going to make for lunch from downstairs, or I'll have to order lunch. Ms. McCarthy? The team downstairs, they're going to do anything for lunch? Okay, all right. Minister.
Thank you, Chairman. Good morning, everyone. As you are aware, the bill comprises 10 parts. The intention is to look at what is provided for, to address any concern that is raised, to see whether there is any anomaly, whether the provisions as drafted will achieve the desired outcome and the intention of Parliament. Insofar as submissions on relevant sections go, we will consider those comments when we are dealing with that part of the bill. Madam CPC, would you want to go through the provisions in terms of the reading while we examine? Yes.
Then we can't move for the confirmation, Minister. Yes. But take them already. It was pretty straightforward. We dealt with the procedures, and we could confirm these minutes. So, by Senator Sinclair, seconded by Member Davis. Thank you. All right.
So, Chairman, we will at least hope to go through parts 1 and 2, and just to indicate that part 2 is the part that we will have to spend some time on, as well as part 3, the licensing authority. Part 4, 5, 6, 7, 8. So we have practically the entire day booked for today's review. CPC will guide us through clause by clause in terms of the reading, and then we will pause at the end of each clause to take any concern, any question, and in respect of those submissions that we have on any of those clauses, we will consider. For example, I see the Jamaica Rifle Association has raised some questions on the interpretation of firearm. When we are going through that definition, we will consider the concern raised. So if we're ready, Ms. Grant.
Good morning, everyone. A bill entitled An Act to Repeal and Replace the Firearms Act to provide more particularly for the prohibition, restriction, or regulation, as may be appropriate, of firearms and ammunition, and for connected matters.
See no error there, so we can tick and go.
Part 1, preliminary. 1, short title and commencement. 1, this act may be cited as the Firearms Prohibition, Restriction, and Regulation Act 2022 and shall come into operation on a day appointed by the Minister by notice published in the Gazette. 2, different days may be appointed under subsection 1 in respect of different provisions of this act. 2, interpretation.
Just before you go, Chairman, do you have an indication as to how the parts will be staggered? Is there any different parts at different times? Coming into effect? Not yet. Very well. Yes. All right.
In this act, acquire means to A, hire, B, accept as a gift, C, borrow, D, receive, or E, come into possession of in any circumstances specified in section 46(1).
CP, their technical team is coming and they're not hearing you clearly because of the mask. I don't think anyone can you maldote it?
I'm not comfortable removing my mask,
Okay.
so I will try and speak a little louder.
All right.
Aerodrome means any area of land or water designed, equipped, set apart.
Perhaps we could just look at the circumstances of possession at 46 to complete the definition of acquire.
All right, so 46(1) specifies the circumstances that constitute lawful excuse for the possession of firearm or ammunition. This includes A, the firearm or ammunition, 1, is the property of the government of Jamaica, and the person is authorized by the government of Jamaica to be in possession of the firearm or ammunition, and 2, the firearm or ammunition is in the person's possession while acting within the lawful execution of their duties. B, the firearm or ammunition is a slaughtering instrument, and the person is a person, 1, with responsibility for veterinary services authorized by the ministry, with responsibility for agriculture, to be in possession of that slaughtering instrument in the lawful execution of that person's duties, or 2, authorized by the ministry with responsibility for local government to be in possession of that slaughtering instrument in the lawful execution of that person's duties. C, the person is an armorer, firearm and tool mark examiner, or the holder of any gunsmith's license in respect of any firearm or ammunition in that person's possession for the purpose of repairing, testing, or proofing the firearm or ammunition. D, the person is 1, the executor or administrator of any estate of any deceased person, or 2, the trustee in bankruptcy or liquidator of any insolvent person who, or of any company in liquidation who, before the death, insolvency, or liquidation, as the case may be, was the holder of a firearm user's license, firearm manufacturer's license, firearm dealer's license, or firearm broker's license in respect of any firearm or ammunition forming part of the inventory in the estate, bankruptcy, or liquidation. E, the person came into possession of any firearm or ammunition in the capacity of an auctioneer, bailiff, or assistant bailiff of a court, or a landlord bailiff. F, the person is an employee or agent of any of the persons referred to in paragraph D in respect of any firearm or ammunition entrusted to the employee or agent for transfer to the owner or to such person who is about to become the owner thereof in accordance with the provisions of this Act. G, the person is a customs officer, an authorized officer, a constable, an officer designated by the Director General of the Major Organized Crime and Anti-Corruption Agency under the Major Organized Crime and Anti-Corruption Agency Act, or an investigator of the Independent Commission of Investigations, and is in possession of any firearm or ammunition pursuant to this Act during such period as such firearm or ammunition is allowed to be retained by such officer pursuant to any enactment. H, the person is a member of the Jamaica Combined Cadet Force in possession of the firearm or ammunition in support of the person's training and development as a cadet. I, the person to whom the firearm or ammunition is delivered for storage in accordance with Section 79, which deals with temporary storage or custody of firearms or ammunition. Or J, the firearm or ammunition forms part of the equipment of any vessel or aircraft or any aerodrome, and the person falls within any category of persons permitted to be in possession thereof.
Any question, comment? Mr. Richards, you can always feel free to indicate for information what the provision is targeted at, just so we can inform.
Can I just ask a question? Acquire is the definition we're looking at. Is there any particular reason, or is there any other definition of acquire ordinarily other than what is listed here? And my question follows with, to acquire, to have, to put in your possession, and by whatever means, seems to be not a term of art, but an ordinary word that wouldn't require a definition separate from what its ordinary meaning is. I just wonder why we have not used the ordinary meaning.
Just to say, it is meant to be more than, so when a word is defined to mean something, then that is the meaning which the legislation uses as opposed to the ordinary dictionary meaning when it is used. And I believe the intention is to cover myriad circumstances under which persons come into possession of a firearm, but the technical team can.
All right, Chair, the C goes to deal with largely what I call the regulated firearms. The other definitions is to cover means of acquiring it outside of that means, hire, accept as a gift, borrow, receive, whatever mechanism. Anyway, let me answer.
So what are we defining here? The means by which you come into possession, or the fact that you are now in possession? Because as I'm reading it, acquire is about it being in your possession. So however, by whatever means it comes into your possession, once it is in your possession, you have acquired it, which is the ordinary meaning of acquire. So why are we defining it as, why are we adding a legislative meaning to it that really ultimately is the same as the ordinary meaning? Because you're not defining the mechanism of how you acquire it here. You may choose to define that elsewhere, but ultimately you're saying acquire is you have it in your possession.
Well, in defining acquire, the focus was really on the mechanism within or by which it comes into your possession. So we're making a distinction between acquiring as well as possessing. So the focus of the definition here is really on the means by which it comes into your possession. So whether it's by way of you would have hired it or accepted it as gift or borrowed it.
So let me ask you a question. If I find it, if I'm walking on the roadside and I find it, I didn't hire it, I didn't accept it as a gift, I didn't borrow it, did I receive it? by finding it on the roadside. Nobody gave it to me. Or I come into possession in any of the circumstances that are outlined in 46.1, then I would not be in possession of a firearm that I find on the roadside, would I?
You would.
Under which definition of acquire?
No, not under the definition of acquire, but for the purposes of possession of firearm, you would have been in possession of the firearm.
But I wouldn't have acquired the firearm, is what you're saying.
But you wouldn't have acquired a firearm for the purposes of the definition of acquire. But the fact of it being
Hold
in
on,
your...
say that again. You muffled a bit.
So you wouldn't have acquired it in the sense that we have defined acquire to be the listed things. Whether or not you would have received it, you would have hired it, or you would have borrowed it. So for the purposes of the definition of acquire in the Act, it doesn't include when you would have simply found it. If you have simply found it and it is in your possession, what you would have been charged for is illegal possession of firearm. But the focus there is simply on the possession, not necessarily the means by which it came into
So
your
by
possession.
virtue of acquire, is there a more serious charge?
Application for investigation, because remember, as we go through the bill, part of what we're doing is plea bargaining for possession of firearm. We require that you provide information on essentially how you acquired it.
Yeah, but Minister, what I'm saying is, for that purpose, then the state would negotiate based on the facts of the situation and the offense that has been committed, and all the details and circumstances around that would be relevant to whatever agreement you arrive at. But for the purposes of an act, see, and this for me is actually, I have probably a number of these interventions throughout this definition section, because I see a number of ordinary words that are being defined in law that whose definition as they're set out here not really very different from the ordinary meaning, and I don't understand why we're doing that.
I would suggest that you could wait to see how it is used, because I think here certainly the definition does narrow the ordinary meaning. So you'd have to see how it's used in the bill, but I think it goes more towards not so much in respect of offenses, but in terms of the licensing provisions. That is where it's most relevant.
Fair enough, CPC. I'll stand down. Thank you.
Please proceed.
Okay. Aerodrome means any area of land or water designed, equipped, set apart, or commonly used for affording facilities for the landing and departure of aircraft. Airstrip means any place other than a licensed aerodrome used for the landing or takeoff of aircraft.
Just a question here in respect of the licensed aerodrome and the definition of aerodrome, which makes no reference to licensing. Is there an anomaly there? Do we have aerodromes that are unlicensed? So the airstrip refers to the place other than the licensed aerodrome. And the aerodrome definition makes no reference to a licensing requirement. Something we just flagged to have it checked, please. All right.
Ammunition means any article consisting of a complete cartridge or round, or any component of a cartridge or round, and includes any A, cartridge case, B, primer, C, propellant, or D, bullet or projectile that can be used in a firearm. Ammunition destruction authorization means an authorization issued by the minister for an ammunition destruction exercise. Antique firearm means a firearm manufactured before or during the year 1890 and which is certified pursuant to this act as being incapable of being discharged. Antique firearm collector's license means a license authorizing the holder thereof to purchase, acquire, display, and be in possession of firearms or ammunition, A, of a type or category specified in the license, and B, manufactured before or during the year 1890 at such place as may be so specified. Appointed day, hereinafter used in or with reference to a provision of this Act means the day appointed under Section 1 in respect to the provision concerned. Armorer means a person authorized by the minister to maintain, test, proof, modify, alter, deactivate, or destroy any firearm or ammunition that is the property of the government. Artillery means any cannon, howitzer, mortar, or flamethrower not commonly in use before the year 1850. Authority means the firearm licensing authority established under Section 20. Authorized officer means A, the chief executive officer of the authority, B, the director of the institute, C, any person designated in writing as an authorized officer for the purposes of this Act by the minister, D, the Director General of the Major Organized Crime and Anti-Corruption Agency or such other officer employed to that agency and designated in writing as an authorized officer for the purposes of this Act by the Director General of the Major Organized Crime and Anti-Corruption Agency, or E, any person employed to the authority or institute and designated in writing as an authorized officer for the purposes of this Act by the Chief Executive Officer or by the director of the institute. Automatic firearm means any firearm designed or adapted so that if pressure is applied to the trigger, missiles continue to be discharged until pressure is removed from the trigger or the magazine containing the missiles is empty. Ballistic signature includes unique marks left by a specific firearm after ammunition is fired or cycled through the firearm. Board means the board of directors of the authority established under Section 21. Broker means any natural or legal person who, in return for a fee, commission, or any other consideration, acts on behalf of others, whether in Jamaica or outside of Jamaica, for the negotiating or arranging of contracts for purchases, sales, or other means of transfer of firearms or ammunition. Brokering includes the exporting, importing, financing, mediating, purchasing, selling, transferring, transporting, freight forwarding, supplying, and delivering firearms or ammunition of such type and at such place as may be specified in a firearm broker's license. Circuit Court includes the High Court Division of the Gun Court and the Circuit Court Division of the Gun Court. Conventional arms means battle tanks, armored combat vehicles, large caliber artillery systems, combat aircraft, attack helicopters, warships, missiles, and missile launchers, and small arms and light weapons and their parts and components. Criminal organization has the meaning assigned to it in Section 2 of the Criminal Justice Suppression of Criminal Organizations Act. Conveyance includes any vehicle, vessel, aircraft, or other means of transport. Customs officer means an officer as defined by Section 2 of the Customs Act. Deactivation means the process of rendering a firearm permanently inoperable so that it can no longer discharge a projectile. Destruction means the process of final conversion of firearms, any other category of conventional arms or ammunition, into an inert or permanently inaccessible state. Digital blueprint means any type of digital or electronic reproduction of a technical drawing of the design of an object. Divisional commander means A, in respect of a parish which constitutes a single police division, the officer designated by the Commissioner of Police to be the divisional commander in that parish for the purposes of this Act, or B, in respect of a police division of a parish which comprises 2 or more police divisions, the officer designated by the Commissioner of Police to be the divisional commander in that division for the purposes of this Act. Firearm A means any one barreled weapon which discharges or is designed to discharge any shot, bullet, or other missile. 2, 3D printed firearm, or 3, prohibited weapon, unless the context otherwise requires. B, includes any parts and components of any weapon referred to in paragraph A. And C, does not include an air rifle, air gun, or air pistol of a type or caliber prescribed by the minister.
We just pause here to consider the submission from the Jamaica Rifle Association on page 3. There is a cover page submission. The submission is organized as follows. Sections of concern is stated, followed by an extract from the bill of the section, followed by a commentary outlining the concern, and finally the recommendations. Are we to take it that persons have a copy?
We have not seen that,
Chairman?
Minister.
Huh? Well, it just has one thing in relation to that. The comments of the Jamaica Rifle Association, but they have not been circulated to the technical team. In respect of firearm, the commentary asks subsection A, nail, so it rehearses the definition of a firearm and indicates that subsection A, nails and rivet guns discharge what could be regarded as a missile. Will nail and rivet guns require a permit? Since the definition says it means any barreled weapon which discharges or is designed to discharge ... missiles. And they're saying, and then subsection B, being in possession of a part or component of a firearm is deemed in possession of a firearm. Persons are currently in possession of parts and components purchased from a dealer or parts removed from a firearm after replacement. And then subsection 3C, the definition of firearm does not include an air rifle, air gun, or air pistol of a type or caliber prescribed by the minister. Does this mean that existing air gun licensed under the FLA no longer require a license? Or will a list be created of all excluded types and calibers? And then airsoft guns or paintball guns are air guns. Are these on the exclusion list or now classified as imitation firearms since they have the appearance of firearm? There is a recommendation.
A moment, please, before you even finish. All right, let me let you finish. I'm sorry.
I'm just reading through. So the recommendation, pardon. It says subsection B, that a qualifier be added to the wording of the provision to distinguish a person who has an FLA-issued authorization for a firearm that the parts or components attached to. And this suggests includes any parts and components of any weapon transferred in paragraph A where there is no authorization for a firearm to which it attaches. And also for consistency in terminology, says the Jamaica Rifle Association, it might be prudent to change the word weapon to firearm in that subsection. You don't have this?
I have not seen it, Minister.
Could we ask the clerk to just distribute the copy? I appreciate that it would be difficult. It's not a long commentary on that section, and so far it's the only commentary we have, only submission in relation to the definition. Member Goldin, through you, Chairman, you want to raise your concern?
Well, the GRA's submission speaks not just in that section, but to different types of firearms. I'm just wondering, I don't have a clue what a nail and rivet gun is, nor do I have a clue about some of these guns that are listed here. Is there anybody who can give us a little guidance on that? Because I'm not an expert on the types of guns.
The nail and rivet gun covered under.
So there are certain things that may not be listed that would still require the approval of the Minister of National Security because they'll be covered under the Customs Prohibition Order. I'm not sure how easy it will be to give a proper presentation on the types of weapons. That may be something that we could do at another session, if the member will agree.
That's fine, but I think it's a necessary step for us to take if we're dealing with a firearms act. Then we, I guess, need to know something about firearms.
Okay, noted.
The rivet gun on the, they come under different sections, right? We have to approve the importation.
Right, so the Minister of National Security will still have to give approval for any other item that's not mentioned here because the Customs agency would not, so they would be included on the Customs Prohibition Order.
Yeah, but current air guns are required FLA license.
Well, they're actually regulated by the FLA. FLA does give licenses.
But nail guns are sold in the hardwares, as are staple guns. And the question, I believe, that is raised is by virtue of the definition of it being a barreled weapon which discharges or is designed to discharge not only shot or bullet but other missile, whether what is discharged from those barreled well, I don't know if it's a weapon, but would place them within the definition. But they are called guns.
Thank you for that, because I didn't know that's what they were referring to.
Yes.
To the chair. So
MP, go ahead.
Yes. So, in my view, wouldn't rivet guns and those other, well, weapons raised by the Rifle Association be excluded based on the definition of barreled weapon? Would a rivet gun contain a barrel? Pardon me?
Go ahead.
Those. You know, I guess we need. I guess we're in a. I guess we probably need, and I join member Golding in the sense that we probably need a proper education on the weapons raised by the FLA or the Rifle Association. Because in my view, the definition says barreled weapon which discharges or is designed to discharge any shot, bullet, or other missile. The issue is a missile, but if it is not a barreled weapon, wouldn't it be excluded? That's just a concern.
But these come on the regular. All right, go ahead, Paul.
I was just noting that based on the examples that I would have seen of a nail gun, that it's not a barreled weapon, so therefore it would not fall within the definition of firearm as we have it. Notwithstanding the fact that it might project a missile in the form of the nail itself, but in terms of it being a barreled weapon, it would not classify it as such.
Mr. Chairman.
How would this apply to the air rifles? Those are potentially air rifles and fish guns, which...
So remember, Minister, you're the authority for air rifles will still have to come through you, so the authority still rests with the Minister of National Security.
May I ask, in relation to the description that is contained in firearm, where they use the term or other missile, having regard to what we have in this bill, which when you look on the definition of ammunition, it relates to indeed bullet or projectile. The definition of ammunition, right? Could we change reference to other missile to bullet or projectile? And probably that would clear up the concern of the Rifle Association. Because it would then confine it to what is contained in the definition. There is no other definition of missile. So it would read any shot, bullet, or other projectile. Or projectile, not other projectile. Bullet or projectile. And the definition of ammunition restricts these to those that can be used in a firearm. And the concern that the Rifle Association has, where they're asking whether it would include a nail and a rivet gun or so forth, then would go through the window. So I'm just putting that on the table.
Well, to be honest,
Definition was taken from where? So, or was it just
which one are the definitions, Minister?
a firearm part A1? Is the same.
So this would have been a carryover from the existing bill, existing act, and it's in the same form. Just to your point, Minister, that projectile and missile is actually used they're actually used interchangeably.
Senator.
Missile and projectile are actually used interchangeably to mean the same thing.
Well, you see, the concern that is raised by the Rifle Association is because the term missile is being used. And they are of the view that a rivet or a nail could be a missile. In the bill, if you were to compare it to the existing Firearms Act, the existing Firearms Act has a reference to ammunition, but this one goes a little further in that it states what is included in the definition of ammunition, and it refers to ammunition as in D, bullet or projectile that can be used in a firearm. That is what the definition is there. So there is no other definition for us to understand what is a missile. And it may make it more clear if we were to, and as I said, it's just a suggestion, that since we have a definition as to what is ammunition, being a bullet or projectile, and remove or other missile, I don't think that would offend. And it may clear up, as I said, the Rifle Association. I see you use missile on page 4 also, where you refer to automatic firearm, pressure to the trigger, missiles continue to be discharged. I don't know, again, probably we could just use the term that is clear in the bill, whether it is bullet or projectile.
We can flag it, no to the suggestion, and then we can come back.
Yes, Minister.
Right.
I was going to say that what Member Sinclair had suggested is actually workable in looking at how it is that the international protocol actually defines ammunition. However, I'm a little bit wary about making these changes now, considering we're just seeing these comments from the GRA, and we would like to sit with the technical team and then make a proposal after.
Makes sense. All right. So we note the concerns and the comments, including the suggestion from the Jamaica Rifle Association, as well as the proposal by Member Sinclair, and we will come back to this definition of firearm. Madam CPC, proceed.
Firearm and tool mark examiner means a person who is experienced and competent in A, the identification, collection, preservation, examination, and interpretation of tool marks, firearms, ammunition, and ammunition-related components, and B, the sequence of events relating to a shooting incident. Firearm authorization means any form of license, permit, certificate, or other authorization listed in Section 57, that's application to authority for certain firearm authorizations, or 67, application to minister for certain firearm authorizations. Firearm broker's license means a license authorizing the holder thereof to undertake brokering activities in relation to firearms or ammunition. Firearm dealer's license.
Sorry, just before you proceed, the other issue that was raised is in relation to the parts and components definition of firearm. And the question is whether persons currently in possession of parts and components purchased from the dealer or parts removed for a firearm after replacement, are these parts to be regarded as another firearm? Parts and components mean parts and components included in the definition. So the simple answer would be yes, if you have parts and components of the firearm. But the question I think they're proposing whether those could relate to where there is no authorization for the firearm to which it is attached. If you're found to be in possession of parts and components and they relate to a firearm for which you are authorized to possess, then I think the concern is that you shouldn't be held to be in possession of a firearm unlawfully, but you wouldn't be in those circumstances. So I'm not sure. We look at that, and they were saying for consistency in terminology, it may be prudent to change the word weapon to firearm. A double-barrel weapon, prohibited weapon, but we note the suggestion for consideration. Yes.
Firearm dealer's license means a license authorizing the holder thereof to buy or sell at such place as may be specified in the license, firearms or ammunition of such type as may be so specified. Firearm destruction authorization means an authorization issued by the minister for a firearm destruction exercise. Firearm disposal permit means a permit granted under Section 64 for the transfer or sale of a firearm or ammunition. Firearm export permit means a permit authorizing the holder to export from Jamaica firearms or ammunition. Firearm import permit means a permit authorizing the holder of a firearm dealer's license to import into Jamaica firearms or ammunition. Firearm manufacturer's license means a license authorizing the holder thereof to A, manufacture in Jamaica firearms or ammunition, and B, sell in Jamaica the firearms or ammunition so manufactured. Firearm shooting range license means a license authorizing the holder thereof to operate a firearm shooting range. Firearm shooting range means a specialized facility operating pursuant to a firearms shooting range license and A, managed by at least one supervisor authorized for that purpose by the authority, and B, designed for shooting practice or for archery or firearms of such type and at such place as may be specified in the license. Firearm trainer's license means a license authorizing the holder to possess firearms or ammunition for the purpose of conducting approved training in the safe use and handling of firearms. Firearm transit permit means a permit authorizing the holder to transport firearms, ammunition, or other categories of conventional arms through Jamaica to another country in circumstances where there is no change in the means of transport through Jamaica to that other country. Firearm transshipment permit means a permit authorizing the holder to transport firearms, ammunition, or other categories of conventional arms through Jamaica to another country in circumstances where the firearms, ammunition, or other categories of conventional arms, as the case may be, are unloaded from one means of transport and reloaded to a different means of transport while in Jamaica.
Through you, Chair, can I just ask CPC, that firearm transit permit and the transshipment permit, are we missing language in the, well, maybe in both of them? Firearm transit means permit authorizing holder to transport, blah, 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 through Jamaica to another country in circumstances where there's no change in the means of transport through Jamaica to that other country. No change in the means of transport, meaning, that's not clear to me.
A plane lands with a...
So if it comes on a ship transiting Jamaica, it leaves on the same ship that it came to Jamaica in.
Or they're flying, they stay on the plane, so.
There is no change in the means of transport through Jamaica.
Through Jamaica on a ship,
right?
It leaves back through Jamaica on the ship.
On the same ship.
On the same ship.
So wouldn't that be better said in the affirmative as opposed to the negative? In circumstances where the vessel transporting whatever is the same vessel that leaves with whatever, as opposed to where there is no change in the means. I must admit I was imagining something where the firearm or ammunition, etc., was then being scuttled from one end of the island to another port. That's where my brain went. So I just wondered if that's what we mean, then why not make it specific to that as opposed to this broader language. And then transshipment permit means a permit authorizing the holder to transport firearms, ammunition, etc., through Jamaica to another country in circumstances where the firearms, etc., are unloaded from one means of transport and reloaded to a different means of transport while in Jamaica. And that's transport out of Jamaica as well. Okay.
Transshipment permit
I'm just suggesting that the language, I don't know if I'm the only one, but it sort of leads me elsewhere.
Where was the definition taken from?
But the principle in the Jamaica, that's major transshipment port, and therefore, and firearms come through here regularly to other countries. The transshipment, they move from one vessel to the other. They come on a big ship from Europe or Far East, and then they go on a smaller ship into Latin America, Central America. When they don't change it, the permit is just for remain. And we approve them regularly, but the language had been advised by the lawyers.
Sure, I'm just saying, if that's what we mean, why not just say so? Its transit permit is it comes through Jamaica to another country in circumstances where the firearm doesn't change vessels. I mean, tidier language and that, obviously, but ultimately, say it specifically. Why leave it open to people like me whose brain work differently?
Well, this seemed to me the pretty simpler way to say it. I'm not sure what other way it could be expressed other than there. I mean, there's no change in the means of transport, as opposed to saying that it arrives on the same means of transport and leaves on the same means of transport. But then that implicit in that is that it would only fall in the definition if it actually leaves. So I think this is the tidiest way of saying it.
CPC, I'll come back to you on that one.
Firearm user's business license means a license authorizing the holder to possess and use firearms or ammunition for the purpose of carrying on a business or commercial operation. Firearm user's employee certificate means a certificate issued pursuant to Section 61. Firearm user's license means a license authorizing the holder to possess firearms or ammunition specified in the license. Firearm user's permit means a permit authorizing an individual not younger than 16 years of age and not 21 years of age or older to possess and use a shotgun, air rifle, or ammunition with the permission of the principal holder of a firearm user's license for that shotgun, air rifle, or ammunition, as the case may be. Firearm user's restricted license means a license authorizing the holder thereof to A, possess, and B, use only within an approved controlled area specified in the license, which may include a firearm shooting range or gun club. Any firearm or ammunition specified in the license. Firearm user's secondary certificate means a certificate authorizing any person who has the written permission of the holder of a firearm user's license to be in possession of and use other than for business purposes any firearm or ammunition specified in the certificate. Firearm user's special certificate means a certificate granted under Section 62. Firearm user's special permit means a permit granted under Section 63. Gun club means a shooting union, association, or other group of persons who associate for purposes connected with the discharge of firearms or ammunition. Gun club license means a license authorizing the holder thereof to operate a gun club. Gunsmith's license means a license authorizing the holder thereof to A, sell, test, deactivate, modify, or proof any firearm or ammunition in accordance with sections 42 and 43. Or B, convert or modify any firearm or ammunition in accordance with section 44.
We just pause to note and consider the comments from the Jamaica Rifle Association in respect of firearms users permit, which means a permit authorizing an individual not younger than 16 years of age and not 21. Page 4 of the printed submission. That's the second leaf on the back of it, page 4. It says, this authorization limits the lower age to 16 years, which is specified. At the international level, inclusive of the Olympics, competitors in the sporting arena are at a very high level, at age 16, and this limitation would mean our competitors at the beginner stage. This limitation would have our competitors at the beginner stage. Additionally, the authorization limits use to only shotguns and air rifles. Minors of age 12 do not participate internationally using a .22 LR caliber rifle, air pistols, or they do participate, and handgun. A minor being a member of the Jamaica Combined Cadet Force could be exposed to using the .22 LR rifle below the age of 16. Under the definition of firearm, air rifles are excluded. However, this provision references authorization for air rifles. Their recommendation that the lower age be changed to 12 years. However, that on the actual authorization, depending on the activity, discipline, or firearm, that a lower limit is established in policy as follows. Air guns, age 12, shotguns, 20 gauge, age 12, shotguns, 12 gauge, age 14, the .22 LR rifle, age 14, pistols and rifles, age 14. That the types of firearms to which this authorization applies be expanded to include air pistols, pistols and rifles. Preferably, all references to air guns be removed for consistency with the definition of a firearm. And then there is also a commentary in respect of the firearms shooting range. But let's, before we get to that one, Minister, these are policy issues.
All right.
I think in respect of the age, I know this type of permit was to enable those who participate in certain activities to be lawfully in possession of the firearm in question.
Well, I think we should look at their recommendations, make a note, but certainly the two last items, the .22 to rifle, pistol and rifles, I would not drop them below 16 for those. And among the recommendations, certainly, I think we should take a look at it, review it, and come back to you. But
Chairman, it's a change, though. In other words, it's a change from what currently exists,
Yeah.
because I know currently you can get a junior license at 12.
yeah, but
So what?
I'm not sure it extends to pistol and rifles. See,
I'm not sure about pistols and rifles
I know
either.
they do
I
air
am
gun,
sure
they do
about the 20
shotgun,
gauge, though.
They do shotguns,
Yeah.
etc. So the
Yeah.
shotguns and the air rifles, I'd be fine, but I think we should look at them. But I'm certain not going to agree to it. A .22 rifle will as dangerous as a.
I'm just curious,
Seriously,
though, what was the policy consideration in applying the 16-year limit?
Right. 16 for those last two items, I think, is adequate. I don't see why I should be giving a 9mm to a 14-year-old to use.
Well, can someone help me understand what's our current position in relation to these on the law? Because the FLA is issuing licenses to 12-year-olds. So are they limited to the particular shotgun or no?
Well, the position is, well, it's really not provided for in law currently.
What's not provided for?
The granting of licenses to somebody who would be a 12-year-old or 13-year-old.
But it's happening. I know of somebody who have a license issued by the Firearm Licensing Authority.
Permit.
So,
Just in addition to that, I think the question that
Sorry,
we have
ma'am. It's license not issued to anyone under 21. In fact, I think it goes for a 24 independent license. I'm not giving anybody below 21. If it is so, something went wrong somewhere in the system. In fact, they have not used age or maturity. In fact,
thank you for that, Minister. I imagine I'll be getting a call.
Right, because in fact we have problem with up to age 25 when FLA has been under pressure for all kind of appeals coming from the lawyers because they have the right to earn.
Is there a difference then if the license is for recreational sport? Because I think in this circumstance, I know of it, it's for bird shooting.
They operate it at the range, but they're not allowed to get independent, like take them home.
Let me check that.
No,
Chairman.
I'm with you, but it's not in the law, but it's a policy of the FLA, which I'm aware is being executed. So if there's a breach, you can check. Certainly not below 18.
So, Chairman, let's just note a few things. Yeah. The permit is issued to a younger person to use a firearm that is licensed to someone else. Right. It's not a license by itself, and you are not independently licensed to carry the firearm. What you're being permitted to do is to use it in defined circumstances. But the question that is raised by the Jamaica Rifle Association really goes to what is the rationale for the choice of 16 at the lower limit. My concern is if it is factually correct that the Jamaica Combined Cadet Force entrusts a .22 LR to a minor below that age, we wouldn't want to make that minor to be in conflict with the law. We wouldn't want to have that kind of situation, and we shouldn't be leaving it to the discretion of anyone. So if the Combined Cadet, the JCCF, as part of its operation, entrusted that caliber to age below, then the question of the rationale, the age, the lower limit, is a live one.
So we have that exclusion in clause 46(1) age, where if the person is a member of the Jamaica Combined Cadet Force in possession of the firearm or ammunition in support of that person's training and development as a cadet. So that person would not be found to be in illegal possession of that firearm. So we have that exclusion there.
46.
46(1)H.
And the legal again jargon is your call, members. But the idea is that the cadet corps is an organized unit, and therefore you can have a lower age of operating, managing, usually using target shooting, but to allow it for general use by as a user's permit for somebody's child who is just for recreation. I think you're stretching it a bit because you may be assured that the quality of supervision by all the parents, because you couldn't make it any exception in that station. So I think, I said we can flag this and come back to it. We didn't see all there's no kind of empirical data say yes, but certainly the difference between organ and established cadet corps unit under the supervision of trained individuals is different from general, even rifle club. Our gun club. Minister Jackson, Member Jackson.
Chairman, just further on that point, I was just curious that I heard the exemption referred to by the gentleman with respect to 46, that pertinent section where those under 16, right, would be exempted, the cadet members.
So we didn't specify age, that it applies across the board, regardless of age.
Okay, notwithstanding, I was just curious though, Chairman, where you have gun clubs, does that restrict the age of persons who can participate in gun clubs? Because that seemed like an organized, permitted gun use activity. And I was just curious, not having gone through in detail, if such a provision exists for cadets, where, as you said, they're under the supervised training of others, why not extend it to other such groupings that we would be authorizing? That's where my thought
before
is.
the technical thing comes in, the cadet is a paramilitary organization. In fact, it falls under the JDF. The commanders fall under the Jamaica Defense Force. I wouldn't equate them with a rifle club, which tend to be selected groups of individuals who can afford to join particular social organization.
I hear you. I hear, and I share you. I understand the sentiments behind the thoughts you express, Chairman. But I was just thinking that if we are restricting it by age, we are saying for that young age, it's okay if you are under the supervision of some authorized persons or responsible persons. So my thought is that if below that age they can operate, they can use the firearm under supervision, why would we? Just curious, why would we restrict it for leisure purpose, like in a club that we approve?
Well, not authorized or responsible. I think the term authorized person is crucial, and certainly, I said, I'd even take it to, if you wish me to say, members of the Jamaica Defense Force or element of the military. I'd be willing to do that, because I think the idea of a 12-year, they go to school and they join the cadet, fine. And the cadet has a particular regime to maintain their firearms. They get it to use for X amount of rounds, particular time. It goes back to the sergeant or the commander in charge, and it's locked away in an armory, etc. Rifle club becomes very. You'll end up with either senior person who just handles it for leisure purposes. I don't know if the discipline is that strong in all the rifle clubs. There's the JGRA, the original club at Mountain View. I don't know how effective the management is in a number of other shooting clubs. And you cannot make an exception for one.
I raised it, Chairman.
I appreciate the
against the discussion we were having about, I think it's the Rifle Association, about competitions and so on for youngsters below a certain age. So if we are embracing some support or endorsement for that kind of activity, then for young persons, why not allow them to have that similar kind of latitude? That was just my thought.
I hear you, but I still think we have to send a signal. The management of a firearm in the Jamaican society has to be very specific and limited to some very rigid protocols. I'm not comfortable with the idea of going to any private club at all, whether they are GRE or non-GRE, for that age group.
Chairman. I appreciate that position, but what is the mischief we are seeking to prevent? We're seeking to prevent firearms from moving out into a space where they're used for illegal purposes, yes? So if that is the mischief we're seeking to create, how is that prevented, or rather, how is that permitted by restricting based on the age category as we have restricted it here? That's my first question. My second question would be, have there been, and is there an issue of guns leaving the custody of the licensed holders in these clubs, etc.? And are we having a problem with that is the question I'm saying, and those guns getting out into the wider society and being used for illegal purposes? That is what would inform how I would agree or disagree with the position.
Let me say a little bit more subtle than that. It's not just a matter of going from the legal to the illegal, which is a problem, and are investigated when they arrive and when there are reports of such. But the firearm, all of them, 22 right up, is a death weapon. It kills. That's what it does. There's nothing in it that's for leisure. Once a bullet leaves a firearm and it gets someone, it kills them. And the members who use it, whether in clubs or not, have to accept a certain level of responsibility. And it's hard, it's subjective, but it's important because we have had people have had firearm license and lose it because they leave it in the car, for example, or they leave it at home out of the safe. It's a sense they don't understand what a weapon is, therefore the power of the weapon, and therefore you have to have them trained in stage where the people are training them, appreciate the importance of it. Just to go on a range for 2 hours every week, give you a complete different sense of what a firearm is. Soldiers are trained to appreciate the power of a firearm. Anybody who appreciates what a firearm is, don't leave it in his car. Don't leave it locked out of a safe and then go home so that his children can pick it up there.
Yeah, but Chairman.
As a member who had his license revoked and applied because it's circled for a read, I sent him to range for 20 hours of training. But another person, I don't want a firearm because a firearm is like a baby.
I agree with you. It is
that's
like a
what
baby.
It is. So there has to be some messaging in the restrictions that send it out there. So I would want to give every gun club, plus there's a certain level of, if you select the gun club, you give permission to manage. Then you get into the social issues of which gun club. Is it the one that you feel is best run, JRA, which is seen to be with a maybe more privileged in society as opposed to the gun club down in St. Elizabeth, which is
No, I'm trying to understand,
farmers.
Chairman, how that impacts the provision on the firearm user permit in relation to the age restriction. Because with all due respect, people who leave their guns in their cars are grown men, usually.
Yeah.
Not 16-year-olds and 14-year-olds and 12-year-olds.
You know what, if you ask me to move this, then we move to the age of adulthood and 18.
No, but I'm saying to you, we currently are in a situation where 12, 13, 14-year-olds can get user's permit.
No, I'm with you on that. I'm saying if I change it from, it's difficult to give an empirical basis for this judgment, but it's a critical subjective issue. But if I move it, I would move it down to a lower age. I'd move it to 18 and say, that's it, you're an adult, you're responsible. Nobody under 18 handler going to get it.
So you're saying that no 15-year-old can get a permit for a firearm for recreational purposes?
No, there's users permit for 15-year-olds within the current law. What I see here is the kind of restriction given. They want air guns to be moved to 12, shotguns to 12 and 14 for 12 gauge, which is a heavier gauge, and the 22 rifle to 14 and pistol and rifles to 14.
Chair, you know what I would wish to benefit from? I would wish to benefit from the rationale of the JRA in relation to this submission. I don't know if it's a function of time. They've set out the things they have issue with and they've made a recommendation. But the rationale would be important to me. So, for instance, are there sporting events where young people are using pistols?
There are sporting events, but I don't think they should be allowed to participate.
You're saying they shouldn't be allowed to
No.
participate? But how can that be our position here if these are international events?
No, it doesn't matter if it's international. Jamaica's situation is different.
No,
I
I
don't
get
think-
that. I get that, Chairman. But what you're saying is that we must restrict young people from a particular recreational activity here, so they would not be allowed to reach international standard, and that doesn't make sense to me from a policy point of view,
Doesn't matter
because
sense.
it doesn't. With the greatest of respect, it does not. It does not assist the policy initiative that we're trying to move forward, which is to prevent illegal guns from killing people. So to restrict a 12-year-old and a 14-year-old from participating in a recreational sport, and I will disclose my hand, I have an interest because I have two boys who, one from the cadet perspective and one from the recreational perspective, who participate in that sport. And you're saying they wouldn't be permitted to, and that, in my mind, does not impact the question of whether or not the gun is illegal and goes to kill somebody. So what's our
What the address
rationale?
is-
We must have a rationale.
No, the
Chairman.
rationale is very simple.
Chairman.
I said the only rationale I could go to would remove it totally. The rationale I'd move to is that nobody under 18 in Jamaica should handle a firearm of this level. So,
So that's a position, that's not a rationale. I'm asking,
No,
what is the rationale
provision
for
is
that? We
firearm
don't have a
is
problem.
No. Firearm in Jamaica is a weapon of mass destruction in plain language. And therefore, whether it is legal or illegal, there must be a sense of responsibility associated with it. And I think limiting the age and the use, as I said, in this situation, 22 rifle, not allowing any junior to use it. Not doing it, Madam Minister. The
Sir,
policy.
I get that, but with the
Right.
greatest of respect, it can't be just your personal
No,
position. We must have empirical bases on which we make these decisions.
Empirical data, Senator, is that every year for the last 20 years we murder 1,000 plus people
Where
in this
do
country.
those guns come
Young
from,
men,
Chairman?
They come across it.
They don't come from licensed users
Some
who
of
are
them,
shooting at
of
bird
course.
shooting or
No.
underage or skeet shooting. They don't come from there.
Senator, 1,200 people murdered in Jamaica by the gun every single year. Guns shouldn't be in Jamaica at all.
Chairman, that
I've
is an
been trying-
emotional response
Chairman,
to what
I've been
I'm
trying to make
asking
an
you.
intervention and simply to ask a very pragmatic question. Are we going to have a benefit of actually having the Jamaica Rifle Association here so that we can be enlightened about some
We
aspects
can have
of
them,
it?
but Jamaica's Rifle Associations are a privileged group. And as part of this, they won't decide, they're a privileged group, and they can't decide the policy.
No, and I agree. Chairman, I don't know if they're a privileged. I don't know if they're a privileged group, but I do think if we are doing, if we are amending the legislation, if we are passing a new
I will
bill,
I'll be happy to have them. But
it's
I'm
just
saying to
that-
you,
Minister, please permit me to complete my point. I'd appreciate that. The fact of the matter is there are some of your members on this Joint Select Committee who are not as familiar with firearms and the rules and the regulations as others. And it would be very helpful if we understood, for example, why it is that the Jamaica Rifle Association feels disturbed about the fact that their persons can't be properly prepared for international competition. I am not attempting, Minister, to comment on your policy or how you feel. I just want, as a member of this Joint Select Committee, to be informed about the positions that I would want to adopt.
for the comment, no, we'll have to have the JRA, but I just want to emphasize that the policy emerged one. I mean, the bottom line, if I could disarm the society, would do so, and we can't do that at this stage. And the senator speaking is quite familiar with the area we're dealing with, but the only rationale they talk is to prepare juniors for international competition. And I'm saying that's not a rationale for the government to change that position. There's no value in it, there's nothing in it except for the pleasure of those who are using it. And there are a lot of things we do. It is pleasurable to smoke. For those who smoke ganja, it's a pleasure. Very relaxing. For those who smoke cigarettes, which we are restricting severely, it is that long-standing recreational activity. And somebody said because there's some data that you may get lung cancer, and there are a number of things. Driving under the influence of alcohol, but the people who drink alcohol are very happy drinking alcohol. In fact, it stimulates pleasure. So I cannot see the rationale with a junior in Jamaica participating in international shooting competition.
Chairman, I just want to add I would like to hear from them, and I plead to, I'm not claiming any, I wouldn't even say abundance of knowledge in this thing. But to the extent that this is an organized body, and as a parliament, we encourage different stakeholder groups to participate in the process to inform our decision-making exercise, it will be useful to benefit.
We have a GRA in it, but remember,
Okay.
GRA, I'm certainly welcome the suggestion, but I'm saying to you that once you get into rifle clubs and gun clubs, you cannot make a distinction for GRA. GRA is the elite traditional club. At once they set the rules, like MCC club used to set the rules for cricket in England. Times have changed. And if we make an exception for GRA, there are several other gun clubs out there would have to make exception for which we could have a problem. And you could not stop any other gun club, in fact. You'll be getting the question of preferences and privileges, right? And as on a personal basis, I said, I was a cadet. I spent a year in the Cadet Corps. We had and for the benefit of members who are younger, I was a cadet when schools had ranges and carried their own rifles. Cornell College had an armory, and we carried the traditional 203 and the 22 rifles. Wolmer's had a rifle range. Mangrove had a rifle range. We had an inter-school competition on firearms. It ceased when they stole the rifles from Wolmer's. Right? That's how it stopped. And all rifles, first we spiked them, which means you made them unable to fire safely, and then we took them all away from the schools. At this point, we are taking them all from juniors. There's nothing could have stopped them from, there's reason, there's rationale for schools to have them. But you can't just, well, say the situation, circumstances change, and they're removed from schools, all armories, and now you have them at the JDF, which also means that only certain people in society would get the privilege of using these shooting privilege, like the people in the corporate area. Because the army is at camp, and the GRA rifle range is at Mountain View. There's none beyond there. We are establishing a base in Montego Bay, but it doesn't have the same facilities as camp. So you're really restricting it not only to age, but if you open it up for a select group of geographical region of Jamaica and a select group of people. There's no reason to do that right now. But we'll have the GRA and they make the case. All right?
Chairman, just to just focus a little bit on what my understanding of the concern of the JRA is. So under the bill, we are authorizing the use of a firearm by persons, young persons, in defined circumstances. In section, and in those circumstances, they would be authorized through the issuance of a firearms user's permit. The permit is defined by virtue of age, so only persons within the age cohort would be eligible to receive the permit. And the permit relates to a type of weapon that the principal holder is licensed to possess. Team MNS indicated that at clause 46, 1H, possession for the purposes of the Jamaica Combined Cadet is accepted because for the purposes of section 45, which says that no person shall be in possession of any firearm or ammunition without the appropriate firearm authorization granted. The following constitute lawful excuse for the possession of firearm or ammunition. 46. We're looking at 46. We're looking at the definition of the user's permit in relation to the concern. So if it is, just hear me out now, if it is that the policy behind the law is to make it lawful for someone who is a member of the Jamaica Combined Cadet Force to be in possession of firearm or ammunition in support of their training and development as a cadet. And if it is factually correct that those cadets may be below the age of 16, then the definition of and it is the permit that would be issued to them to authorize their lawful possession, then this definition would render it impossible for the FLA to issue such a permit if the person is below the age of 16. Let's look at it in conjunction, because it sets a limit. It's between 16 and not yet 21. And if it is that the cadets are under 16, it is not the policy, then the question is, what would
Minister,
you authorize them with to be in lawful possession of the firearm or ammunition for the purpose of their training and development as a cadet?
I understand the cadet doesn't need a permit, Once they are a member of the cadet corps, the cadet unit gets a permit and trains them. At the moment, the ministry is on a mission to have cadets in every school. And therefore, all cadet members would have access, because they do camping outside of the school in the summer, and they get access to use the firearms. So there will be no discrimination against any geographic or social grouping. Anybody under 16 who wishes to use a firearm should become a member of the cadet corps. It carries a certain training, certain discipline, and supervision that is not characteristic of any other body. It's a sub of the Jamaica Defense Force, so they get the exception. And the character training and development that come with being a cadet. It's an entire system. And it's the part of the move to change the attitude of our young males in particular, but it's to all our young adults, youngsters in schools, is to open cadet corps in all schools. I think there are only about 40 left. I don't want the exact numbers that don't have cadet corps in them. The Minister of State, is being prevented to get all those schools on board. The budget was tight last year, but ultimately would like all schools to have cadet corps, and it moves on into the JNSC Corps or to other activities, but it is extremely valuable in terms of personality and character development. The other organizations don't have that, and so the objective would be to ensure that as we proceed, youngsters can leave the cadet corps into JNSC if they don't go into college and university. And from Jamaica National Service onwards, it's a body we hope to get to about 10,000 in the near term.
Chairman,
Sorry,
what we are...
Oh, sorry.
Yes?
I just wanted to find out, is there another provision that says that the member of the cadet don't need a permit?
You're going down where I was about
That's my
to go.
understanding. The individuals don't need permit.
But where in the bill does it say so? The bill would need to me,
I understand that
I don't think
clause.
46(1)H.
So
46(1)H is just saying you're in lawful possession. But if you look at the other persons, so are you saying that none of the persons in 46(1) need permits at all?
I want
So it's either,
and
if that is the case,
corps.
I think it should really be stated very clearly.
Yeah, I accept I need to state it clearly, because the cadet is being treated like is a cadet of the Jamaica Defense Force. Jamaica Defense Force members don't need license or permits once they are registered members of the JDF. So it comes under that global picture. The soldier doesn't need a permit to carry a firearm once he's a member of the JDF.
So I understand. It's just that when I looked at 46(1)C, like the armorers and so, I would have thought they do hold licenses. So I don't think it's clear that then 46(1)H means just because of where it's placed that the person would not need a permit, just in and of itself. But I don't, that's not my interpretation when I look at the clause as a whole.
Chairman,
I'd be advised. I just to state the policy. I want to be made clear. That's the reason why the cadet would not need a permit. If it's not stated clearly, then it needs to be clear.
The issue is a little wider, but I do agree with the concern raised by the SG. When you look at 46, the circumstances that constitute lawful excuse for possession. And the reason why this is so important is because of the consequences of someone being found to be in possession without the appropriate authorization, because we'll come to that. But so we will have to clarify among the categories here at 46.1, which relate back to the definition of acquire and how acquire is used in the law, who needs authorization and who doesn't. All right, but it does appear that the person who is in possession by virtue of falling in these would not be deemed to be, well, we just have to clarify that.
Minister, 46H would not cover the cadet adequately.
40?
1H. That's not covering the cadet adequately.
Well, it says yes, because for the purpose of section 45, the following constitute lawful excuse for possession of the firearm. And among them is a person who is a member of the Jamaica Combined Cadet Force who is in possession of the firearm. So it can stand to reason, though you get to there not immediately, that these persons may or may not have a form of authorization, but if they can establish their relationship as a member to the cadet force and they're in possession, then the possession would constitute a lawful excuse, or their membership in the cadet force would constitute a lawful excuse for their possession.
So, Minister, just to make the point quickly, in terms of the categories of individuals listed under Clause 46, these are individuals who would not be in possession of a firearm authorization. They may be authorized in some other respect, as SG would have alluded to in the case of, for instance, an armorer. They would be authorized as an armorer. However, in the case of somebody who is a cadet, they're a member of the cadet force by virtue of them being a member of the cadet force and by virtue of them being in possession of the firearm with the objective of training, that excuses their possession. So there is no need for an additional authorization in relation to the firearm possession, because by virtue of their...
Let me ask another question of the Minister and the technical team. This doesn't mean the cadet can leave the range where he is on the supervision.
That's where I'm...
I know we may have to look back at how it is provided for. Madam
the person's
CPC?
training and development is a cadet.
Yeah.
Can understand, can enter, but if there's a problem, because what I don't want a loophole that he can then leave camp or Twickenham Park, wherever they are.
Right.
And in his uniform and walks up to the JRA or Stony Hill Gun Club and starts shooting away until they're gone.
Yes, that is the point I was going to make, because the way it's expressed here, it's limited to the exclusion is limited to the particular circumstances. So it's a different thing to say that the person point blank is not required to have an authorization. The way it's expressed in 46, it only covers the exclusion if the circumstances described there are satisfied.
Another look at the language so we can take out any doubt from it. But there is just one other. So, Madam CPC, just flag it, because I think we may have to just revise how it is provided for to avoid unintended consequences and putting the youngsters. But the other issue that the Rifle Association raised is in respect of authorizing persons for the sporting event. And DPM Chairman, the policy is to authorize persons who are engaged in the kind of sporting activities that we permit, that we allow, to be lawfully in possession of the firearm. And if what they're saying is that we have young persons, I mean, Jamaica is a sporty nation. We may not currently be involved in all categories of sports, but we do have we are an Olympic nation, we are a world championship nation, and other sporting activities. And it is certainly not the intention to criminalize persons who are lawfully engaging in sporting activities and who need an appropriate permit to do so. And if it is that we have persons younger than 16, because what the Rifle Association is saying, that by the time you get to 16, you'd be almost regarded as an expert in certain categories. And you would need to have persons below that age authorized for the purpose of training and participation in the activity. And the 16 would cause a problem if it is a permit.
They join the Cadet Corps?
No, but the Cadet Corps wouldn't.
No, I'm very serious.
Hold on, Minister.
If they want, they join the Cadet Corps.
That still wouldn't enable them. That still wouldn't solve the problem.
Yes, it solved the problem. They get the training. And when they're going to the training, they're not allowing any clubs. First of all, GRA does not represent all firearms in Jamaica. GRA is a very exclusive club of firearm holders which has a certain standard. I agree. I said that the best thing I can give are those who play cricket. Melbourne Cricket Club used to set the rules for cricket globally until they fall apart and the money went to India, etc., etc. But that was a selected group. There are 20 licensed ranges and about 15 gun clubs across the island, and they'll have to be treated equally as GRA.
I don't think it's the issue is limited to the
GRA.
GRA.
They allow sporting, they have sport. Look, more sports shooting took place at the central dealers, which were locked down by this government, by the law, by the police. For different reasons, that's where most of the shooting took place as sportsmen in Jamaica, in terms of sheer volume.
All right, so
we're getting it reopened because we have gone through the protocols.
Sir, can you say that again?
So,
So the response, Chairman.
I said that more sports shooting took place at central dealers than at GRA.
At Central where?
Central Dealers Range.
For the
and there's a club in South St. Elizabeth, I forget the name of it, and there is one in Negril, there's one in St. Anne. They're all over the place. GRA does not represent the sport shooting fraternity in a singular way.
Understood, Chairman, but let's be clear now. My understanding of the inquiry is that it's not limited to JRA providing the service of training sports athletes in rifling. It's anyone. And if it is that for persons who are involved in the sports of rifle, which includes a rifle, and what they get is a user's permit to enable them to be lawfully in possession of the rifle or whatever other weapon, firearm that they use. If we set the limit at 16, we would be removing persons below the age of 16 from being lawfully authorized to possess a firearm, to train and compete. If our intention is to lock it off from them, then we have no problem. If it is not our intention, then we will have to revisit and have a rationale for the age.
An error. Under 16, under 20, the person in sports, the young person in sporting activity does not own a firearm. It is still owned by the individual.
It's a permit here, not the license.
I'm saying, so the permit is used. I'm saying that person must go join the Cadet Corps. And they will say, I'm not, look, this thing is...
Chairman, I understand what you're trying to say now, but to suggest that someone who is involved in sports...
It's not
the Cadet Corps, with the greatest of respect, the Cadet Corps does not train you to do clay shooting.
Well,
that's not how they train you. The Cadet Corps is training young men to responsibly hold and use a firearm in the context almost of a military type training. That's a completely different activity.
And a rifle for sporting, yes, is used, but I don't see why we should do it. People shooting people in the inner city for sport.
Chair, would it be appropriate perhaps to ask for some data on where
No,
the...
I don't.
No,
data,
let
the
me finish,
data,
please.
Ms. Senator,
Let me finish, please.
Senator, no. There's no more data than that this country kills 1,200 of its people since 2020.
No, Chairman, I'm sorry. With the greatest of respect.
Banning firearms.
But that data has to be disaggregated if we're writing...
Senator.
No more data?
As a government member, 1,200 people are murdered in this country, sometime in groups of 12 and 14. Right? That's what firearms do in this country. And therefore, there is no privilege for anybody in this situation. Ideally, what should be doing is banning firearms. That's what the number states.
No, Chairman, the number does not state that in relation to this provision.
I'm saying to everybody, there's a lot of...
I understand your concern. I share your concern. But if we are writing law, then we must write provisions that are responsive. Chairman, let me get it out, please. That are responsive to the problem we're trying to fix. We do not fix the problem of illegal guns and the killing and murders going on in Jamaica by restricting 12 and 13, 14-year-olds who are involved in a sporting activity. And so my question to the technical team is, what data do you have that indicates that persons who are involved in sporting activity are leaching guns into the society that are being used to commit murders? That is the question that must inform this position and this provision. We can't write law on the basis of how we feel.
Madam Senator, no, don't answer. We have had cases, serious cases that taken us into the national circuit of private clubs operating which have had issues in sporting firearms, which not only we had to deal with legally, but we came under international pressure for the abuse of sporting firearms. Now, if you want to discuss out of here, we can discuss it. They end up having to justify buying thousands of rounds, which leaks into the system. So that's not for about that. Right?
Chairman, I hear you, and I'm not aware of that. I'd be grateful for it, though. I'd be grateful for that information so that I could look at it myself. I would appreciate it.
JRA does not in any way represent the sporting association in Jamaica. The sporting club in Jamaica is one single club, and it cannot be taken out and given a privilege that others can be given. And there is no way this country can allow all the shooting clubs in Jamaica to operating to involve kids at this age group in the use of firearms and rifles.
Right, Chairman. May I suggest that we note the issue of the lower limit for further consideration? And, Chairman, earlier you had acceded to the request of Senator Scott Motley for the presence of the representative, just to enable a better understanding of some of the matters, so that we can move on. Thanks. I see the committee is going, this is going to be an interesting committee deliberation.
I was alerting you. I was alerting you when I mean, we're not going to lower the age, we're going to increase the age, because if the object is to, I'm saying to you, member, I want to lead on it because I don't got a person, but any change in the age group here will go towards the age of maturity. I'm serious. It is something that I've given thought to, that this country not allow anyone below the age of 18 for any reason at all to handle a firearm. That is really what we should be looking at.
Just to clarify, because I think a lot has been said, we just want to clarify the policy position that would inform the legal provision on the authorization of persons below the age of 16 to participate in sporting activities involving rifles or firearms for which an authorization would be required. So just to note, DPM through you. Member Goldin, you have one other issue because we have to move on.
No, before you move on.
Title, everything.
Before you move on, Madam Minister, can I go back to the definition of firearm and tool mark examiner? I know we kind of went through it really quickly. The firearm and tool mark examiner means a person who is experienced and competent in A, identification, collection, etc., and B, experienced and competent in the sequence of events relating to a shooting incident. Is that what we mean to say, or experienced and competent in the identification and analysis of the sequence? Is that what, to me, there's a big difference. Is that, I put that, I guess, to the CPC. Because the firearm and tool mark examiner is the person who is now analyzing and determining what are the sequence of events leading up to the shooting, is that correct? Or analyzing it, well, let me ask the question.
The firearm and tool marker examiner.
So that would be page, 6, top of page 6. I'm assuming the firearm and tool mark examiner analyzes all the issues and events leading and arising from the shooting. So is he competent in the sequence of events, or is he competent in the analysis of?
The analysis.
I mean,
he's
he's not the one that ran up and shot the man.
No. It's the analysis member.
Yeah. So I just want to make a note of that.
All right. So just for those who are tuned in, it's going to be critical that we're very clear about who is authorized to lawfully possess firearms, because when someone is not so authorized, the consequences are going to be severe. And we don't want to have any loophole, and then we have someone before the court, which is a concern that is raised in the public, that, for lack of clarity and unclear language, there may be unintended consequences and persons are caught. That's why we have to be very, very clear in ensuring that what we intend is what is provided for in the law, because there is going to be no mercy after a certain point.
Chair, one more before we move on from this last bit that the CPC went through. The firearm user's secondary certificate, almost to the bottom of page 8, means a certificate authorizing any person who has the written permission of the holder of a firearm user's license to be in possession of and use other than for business purposes any firearm or ammunition specified in the certificate. Is it the firearm or ammunition specified in the certificate, or the firearm or ammunition that is specified in the firearm user's license? Because whatever is in the certificate is what is to be in the license, yes? So the specification really ought to reference the license or the certificate? I think it's both, yeah.
It has to be both,
I think
because
I have a note here that
the
it should be at the same
certificate would
time.
specify what is in the license. So both would have to coincide. Madam CPC, just look on it.
But is that necessarily so? Because couldn't the license authorize something broader, and the certificate be authorizing a narrower category than what is covered by the license?
Very much so. It could. The license holder may have.
Call this for, again, information, Minister. This particular certificate, I don't want to be specific, but the bird shooters, for example, will allow bird shooting season, a person that will use a certificate for somebody's license. Essentially, that's where this is particular use. So if I have a shotgun and I want my cousin to shoot, you can apply and I give permission, and they get a user's permit for the time of the bird season. And they have to, I think they're allowed to buy the ammunition is to come to a licensed firearm holder. But that's really the area they're looking at, when you get permission for somebody else to use firearm. But I just
Question,
want
though.
but I'll be advised on the legal
DPM,
jargon.
the question is whether the license, when a license is it issued in respect of more than one firearm, a single license, or do you have...
The user certificate would have to be in with one license.
Bear with me, just
No,
walk. Right. What you say is correct, but there is something else before we get there. If a license, user's license, because it's defined as a license authorizing the holder to possess firearms or ammunition specified in the license, it means that you can have a single license for 3 or 4 firearms, or for each firearm you get a separate license. One license for the 3? In that case, if that is the case, we should take off the S of the firearms there, Judith, maybe. I mean, I know Interpretation Act. Possess firearms or ammunition. And then, if that is the case, the certificate, what is specified in the certificate must match what is specified in the license. So it's not a case that the certificate would authorize a subset of what is in the license. If factually it is that a user's license relates to one firearm and not multiple firearms. Good point.
But even if that's the case, would the certificate not also have to include a specification? So I think
yes.
So
yes.
It would still be correct then to require the secondary certificate to specify the firearm or ammunition.
So it would be specified in the certificate in accordance with what is in the license. So it's kind of both. So what is specified in the certificate must match back what is on the user's license. And that would have to be made clear.
Minister, pardon my lack of intense knowledge with these differentiation, but just thinking about some real scenario. From what I'm hearing, someone who gets a permit for a firearm, the permit is restricted to that particular firearm, correct? Suppose a circumstance arises where my good friend, member Sibley's, who is a licensed firearm holder, not in possession of his licensed firearm, but is a licensed firearm holder. Somebody attacks someone in his presence who is a licensed firearm holder. He got injured, got shot. He is able to retrieve the injured licensed firearm holder, uses licensed firearm in protection of his life in the circumstance. He will now be using a firearm to which he was not licensed. Would he then be guilty of an offense?
I think the law covers that, and I prefer the technical people apply it to discuss. It was raised on many occasions. If you
so is that two regimes?
From my understanding, it's covered where you, for a particular purpose, get in possession of a firearm in that context, and it is self-defense is still standard. But I'll allow the lawyers.
Well, I'll listen.
Clarify for Member Jackson, this bill has two regimes. One involves the use of firearms that are lawfully acquired and are registered, right? But you may also have a firearm that is registered and may be used unlawfully, or may be used by someone who is not authorized. But that firearm is in your database. And then you have the other side, where the firearms are illicitly trafficked and there is no registration or record of them in the FLA, in the licensing system. And that's a different kind of treatment for those persons. It will become clear when we go through the bill.
Chair, I had one last thing in that same section on firearm users' special certificate, which is just below the secondary certificate definition, means a certificate granted under Section 62. Section 62 reads, upon an application made under Section 57, the board may, after consultation with the divisional commander, grant a firearm user's special certificate to a specified group or person, authorizing that group or person, as the case may be, to possess a firearm or ammunition for restricted use as specified under subsection 2. Subsection 2. A certificate granted under subsection 1 shall be restricted for use as specified in the certificate and within the areas specified in the certificate, which may include the shooting ranges, the gun clubs, theatrical film or TV production, location of an athletic meet where the firearm or ammunition is to be used to signal the start of an athletic event. My question is, in relation to the theater, film, television, etc., anywhere where it's used for creative production or at an athletic meet, does this certificate also, well, let me just ask the question directly. How do they get the gun there? Because they're only allowed to use it in this location. So how do they get the firearm from wherever it is to the set of the movie production? And who does the carrying? Because there's no authorization to carry it there, but there's an authorization to use it there.
So the provision 62, clause 62, what the certificate allows it to do is both possess and to use. Subsection 2 is focused on the use. So if it is that you are found on your way to that location, you are merely in possession of the firearm at that point. The certificate would have authorized you to be in possession.
Okay, thank you.
Just to go back, though, to the definition of firearm users' secondary certificate and the issue that we had as to whether or not the certificate must perfectly match up with what is in the license, just to note that, say, for instance, the certificate could authorize the possession of 10 rounds of ammunition. That might not necessarily match up with what is in the license, because the license may authorize the permission or the authorization for 50. So just to make sure that we're not continuing along the line of that the certificate must match up perfectly with what is in the license. The focus here should really be on what is specified in the certificate, and that is what authorizes you to be in possession of a firearm and then a specific amount of ammunition or number of ammunition.
The question that the CPC had posed becomes a live question in respect of the ammunition part of it, but she'll know how to fix it. We can continue.
Okay, so Gunsmith's license means a license authorizing the holder thereof to A, sell, test, deactivate, modify, or proof any firearm or ammunition in accordance with sections 42 and 43, or B, convert or modify any firearm or ammunition in accordance with section 44. Holder, in relation to a firearm authorization.
Can I just interrupt for a question? What does it mean to proof a firearm? What does that mean?
One moment, please.
Test is different, you know.
Right. So it specifies testing separately from proofing. That is in the order.
In very simple terms, member, is just testing to see whether it's real. So I'm trying not to use the same words that says testing. It's just doing something to check to see whether or not the firearm is defective.
Oh, and so that's different from test? What would testing a firearm be?
I'm not going to mislead you, member.
Gunsmiths will know.
Right. I'm not going to mislead you, so I think that there's some very technical definitions, distinctions that I would not want to mislead. So I'd propose that when I do the presentation on how the firearms, types of firearms, that I also bring that as well.
Okay, great. Thank you.
Already we're seeing that legislators will have to be provided with some more information around the use of firearm and what falls under the law.
I said in my short presentation, Minister, that this was a new bill, total new bill, and it has some innovations in there and some which will raise questions, and that's why we allow time for some reading and absorption, and we prove to it because we have to get it through, right? But I know and understand the technical terms that we further explained. Right? So, with you. In addition to your JRE, you might have to ask the armor from the JDA to come and explain something.
We'll license the gunsmith to sell, test, deactivate, modify, proof the firearm in accordance with the provision. Yes. Holder?
Holder, in relation to a firearm authorization, means the person to whom the authorization is granted. Imitation firearm means anything which has the appearance of being a firearm but is not a firearm, whether or not such imitation firearm is capable of discharging a shot, bullet, or other missile. Institute means the institute of...
Sure. That one is interesting. I read it a couple of times, and I must tell you, I'm a bit puzzled because it seems on the face of it, it seems a bit vague. And as the minister pointed out, breaches under this act can be very severe. And because of that, we have to be careful that people are not caused to suffer very dangerous consequences unintentionally. I'm thinking of, for example, a child. No, I think you get a sense where I'm going. By virtue of what I read here, and I just want us to be detained a little bit on that, because I have a strong reservation against innocent people falling afoul
Chairman,
of the law unintentionally.
Mr. Jackson, I'd ask the team to respond, but my understanding of this is the use of it. In the case of possession of an imitation, I'm not sure there's any heavy charge on that. It wouldn't be the same as in charge of an illegal firearm.
Yeah, it's the possession of it. If somebody make up something and try to use it as a firearm, that is clearly out of the thing. I'm just having something in their possession.
You reminded Member Jackson that the existing Firearms Act has this provision. So this is not part of the innovation. And it is an offense to be in possession of an imitation firearm. To use
in certain circumstances, yes.
Right. So under the existing law, there is a definition of an imitation firearm, and at Section 25? Right. Section 25 provides that, may I just borrow it? Every person who makes or attempts to make any use whatever of a firearm or imitation firearm with intent to commit or to aid the commission of a felony or to resist or prevent the lawful apprehension or detention of himself or some other person is guilty.
Fine, I'm good.
All right.
I'm good. She said that the definition of the imitation. That the definition of an imitation firearm is covered under the is it FLA Act? And the definition she read.
In the current section 25(5), firearm and imitation firearm are defined, and under the Act, the imitation firearm means anything which has the appearance of being a firearm within the meaning of the section, whether it is capable of discharging any shot or bullet or missile. Right. That's the existing definition. And it is the same.
Which act?
Old Act,
In the current.
Oh, in the old one. Okay.
In the existing law.
Section which? Which section?
25(5) in the existing law.
No, man.
Not the bill, you know. Where you were concerned
Not a
whether
new
we
bill
were creating something
old
new
Firearm Act.
in respect
Is
of
this a
an imitation firearm. And the
transfer
answer
to
is no. It's an existing provision. The definition of imitation firearm is now in Clause 2, which is a definition section, as opposed to the section which provides for the use of it in the old law. Proceed.
Institute means the Institute of Forensic Science and Legal Medicine. Jamaican waters means Jamaica's international waters, territorial sea, and archipelagic waters as defined under the Maritime Areas Act. Manufacture in relation to firearms, ammunition, or other related materials means the process of, whether manually or otherwise, assembling the firearms, ammunition, or other related materials from parts and components or any other elements or materials.
Let's just pause to note the comment of the Rifle Association. Performance of a firearm is a vague term. Well, they've stated modification and says that performance is a vague term. How is performance to be assessed? Is performance improved accuracy? It can be argued that nothing can be done to a firearm by itself to improve accuracy. It is a combination of shooter and firearm that delivers improved performance, such as accuracy. The manufacturers of the firearms created a set of activities that are to be executed by firearm users that were intended to modify the function performance of the firearm. Example, changing the choke of a shotgun, stretching magazine springs, changing seals, changing grips, changing recoil spring, dependent on the ammunition being used, making adjustments to the adjustable components of the firearm to suit the user. The provision as worded creates legal jeopardy for the licensed firearm holder. It is difficult, if not impossible, to create an exhaustive list of all the possible manufacturer allowed changes and adjustments for all the models of future and existing designs of firearm. And their recommendation is that modification be limited to and defined as alteration and effecting repairs that affect the ballistic signature, barrel length, identification marks, or diminish the sound caused by the firing of the firearm.
Minister, with all due respect to the position of the GRA, and I want to say again that I'm a little uncomfortable making these kinds of decisions on the fly, having not really studied the comments. But I think that if they want to if anyone wants to modify a firearm, they should become a gunsmith, and that is what the FLA is going to give them the authority to do with a gunsmith license. I don't necessarily agree with the proposed definition, but once again, I would prefer to sit and discuss this with the team before we make that.
Just to be clear, naturally policy decisions can't be taken on the floor here. We are having invited comments. We are noting the comments in the process of deliberation, but they would have to be considered whether they would be accepted, rejected, or how they would inform any review of the particular clause to which they relate. So it's not expected that any of the decisions would be taken here, having regard to the process by which we make policy that goes behind the law.
Minister, I made it clear that the JRA will be brought here to make the case. It doesn't mean it will be accepted. Right? I am obligated to listen. Remember that.
It's just a process of review, Chairman. We do take into account comments that are raised on the provision.
Can I just ask a quick question? I did read through, but I can't recall. But the term modification is used specifically where would the offense be that relates to modification? And that may probably also clear up the issue.
So, clause 42, restriction on modification of firearm.
Pardon me?
So you have clause 42.
42.
42, restriction on modification of firearm by Gunsmith. That's on page 36. We also have clause 43, sale, testing, deactivation, modification of firearm.
Okay, so it relates to the gunsmith.
It also applies generally. So 42 is in relation to the gunsmith, yeah. 43 is of general application, and
right.
And I believe section 30
right. So
as well.
You're seeking to restrict that to
yes. So the policy is no modification should be made to a firearm without the authorization of the FLA, and it should not be done unless it is being done by a gunsmith.
Yes, yes, and then you have to also then look on 13, because I think 13 is what probably.
Understanding of the concern raised by the Rifle Association, the concern is not about who does the modification or where it is done, because the scheme of the law is that any modification, there is restriction on modification, and modification would have to be done by the gunsmith who is licensed as a gunsmith, and it can only be done in respect on the premises in respect of their license. They're licensed to do so. But what I gather from this issue is that manufacturers of firearms permit modification to be done within a certain limit. And so by changing certain things, what the law is saying, if you possess a firearm and you intend to have it modified in accordance with what is permissible by the manufacturer, you'd have to take it to a gunsmith to have it done. And the gunsmith, in turn, can only do the modification on the premises that he's licensed to do so. So we don't have activities of things going all over. But what the Rifle Association is saying is that the way you define modification, you may actually prevent someone who wants to take advantage of what can be modified lawfully from doing so.
What can be modified by the manufacturer, and say lawfully. We are making it unlawful in this case, because what you get is the hobby gunsmith who in the rifle club who figures he can do anything to the firearm because he has the skill set to do so. And he gets the privilege of amending the firearm, whether the sights or the barrel or whatever it is, which does impact on how the balance of the rifle operates. Now, he does it for a friend who might be responsible, he don't know. what you're doing is restricting the modification to someone who is licensed and monitored and validated on the premises where it's allowed to be done.
So that would
Again,
then be the answer.
It's a restriction on the possession of a firearm.
But that provides an answer. So whereas we understand what they would want to achieve, we're saying when you acquire the firearm and it is licensed, we're not going to permit any form of changing that is going to affect the performance of it and allow it to function differently. It's not just about our being able to trace the ballistic signature, because what you do with it can make a difference.
Yeah.
So that would be the answer to that concern. But the concern did make sense. But the policy is even if the manufacturer allow you, once we license you in respect of that, there is going to be restriction in respect of what can be done.
Part of the new act actually is designed to put a unique number on parts of the firearm. That's when they are licensed out. The FLA will have the equipment on the new law. They'll be required to put on, in addition to the serial number which is manufactured with, they have to put on a Jamaican serial number, put it that way, on both the barrel and any movable part in it, so that it can all be brought back. That firearm can be identified by its parts or otherwise. And ultimately, there's a photo electronic means we intend to actually mark the bullets, but currently the equipment to do that is a little bit tedious. But by the time this act is activated, we should have the equipment to do so. When the firearm ammunition comes in, they'll be marked before they go to the dealers.
I understand that the law is going to provide for, is providing for the markings of all firearms so that we can trace them. All firearms that are lawfully acquired and are entered in the database will have their ballistic signature. So, you'll be able to identify them uniquely and trace them to the person who lawfully acquired them initially and subsequently at all stages. What I understood, the issue here is that, and we're restricting anything that would cause any difference in the function or performance of the firearm or ammunition. And that is broadly put. If that is the policy, then that is the policy. Whether the manufacturer says that you can change the grip, or you can change the seal, or you can change the coil spring, none of that is going to be permitted.
It has to get it done by a gunsmith. And if it's a movable part that's marked, then the gunsmith will have to get.
But here is the issue. Here is the issue.
If it takes all the barrels, for example, the stock, which has its number on, the gunsmith will then be under the obligation with license to inform the FLA that's being done.
No, but the issue that is raised is a little more nuanced than that. If it is that we're permitting such things that the manufacturer allow, but that they can only be done by the gunsmith, then we really will have to look back at modification. Yes. So let's just flag it, because the gunsmith is not going to be permitted to modify contrary to the law. You can only modify in accordance with the law. And if you restrict modification except by the gunsmith, let's just make sure that what we intend is what is provided for.
Parts and components means any items that can be attached to a firearm, or any items or replacement items specifically designed for a firearm and essential to its operation, and includes a barrel, frame or receiver, slide, cylinder, magazine, firing pin, mainspring, bolt or breech block. B, any part deemed essential for the functional operation of the firearm. C, any part designed solely or exclusively for converting a semi-automatic to an automatic firearm. And D, any device designed or adapted to diminish the sound caused by firing a firearm. Prohibited firearm means A, any artillery, B, any automatic firearm, C, any rifle of a prescribed caliber, D, any light machine gun or heavy machine gun, E, any submachine gun, F, any firearm in respect of which no firearm authorization is granted under Part 5 or under the laws of another jurisdiction, G, any other type of firearm prescribed by the minister, or H, any parts and components of any item referred to in any of paragraphs A to G. Prohibited weapon means A, any prohibited firearm, B, any grenade, bomb, or other like missile, C, any missile or missile launcher, D, any projectile or rocket manufactured to be discharged from any item referred to in any of paragraphs B to C, E, any imitation of any weapon or device referred to in any of paragraphs A to D, F, any ammunition stockpiled in the quantity referred to in section 6(2)(b) or in a person's possession in the quantity referred to in section 10(2)(b)(2), G, such other weapons or devices as may be prescribed by the minister, or H, any parts and components of an item referred to in any of paragraphs B to G.
Just before we proceed, Chairman, I know you would want to draw members' attention to these definitions because they are critical to the innovation or innovative policy behind the dual regulation of firearm. So we have a side where certain things are prohibited, both by way of firearms as a subcategory and then weapons, including the prohibited firearms and others. So we just alert your attention to this, draw your attention to these two definitions. Prohibited firearm and prohibited weapon, because there's a different penalty regime in respect of it and how persons are treated.
Where did she reach?
Yes. Can I just make one? Sure.
Can I, I'm so sorry to have to take us back, but can I just look back at parts and components and suggest that we could delete paragraph B of parts and components, since parts and components is already defined as any items that can be attached to a firearm or any items or replacement items specifically designed for a firearm and essential to its operation. So that B, which includes B, any part deemed essential for the functional operation of the firearm, might be repetitive and probably unintentional.
Can I seek some clarification on a matter after? The definition of the prohibited weapon, it includes any ammunition at F, any ammunition stockpiled in the quantity referred to in section 6(2)(b) or in a person's possession in the quantity referred to in 10(2)(b). But when I look at 6(2)(b), I want to be clear because it says that if you have 50 rounds or more of ammunition, then you are stockpiling and you would be in breach of a stockpiled prohibited weapon. So if you you have a legal, you're a licensed firearm holder, and you get permission to, as they have done, to have 50 rounds of ammunition. I'm not clear on what it is saying. Is that the fact that I have 50 rounds, does that mean that I'm in possession of a prohibited weapon? Of illegal?
There's a separate accountability for illegal possession and stockpiling. If you are, this would not apply to the person licensed firearm having 50 rounds. a person outside a person in possession of an illegal firearm who has a magazine of firearm will be charged with legal possession. If he has more than 50 rounds, he'll be charged with legal possession plus stockpiling. That's illegal. We are referring here to the illegal possession of illegal ammunition.
And this is what this is saying?
Yeah. Well, that's what it's supposed to be saying. And I expect that's where it applies. And I think that's why the penalty is supposed to be included in 6. Right? That's why it's included in 6 as opposed to the schedule which governs the registered firearm. So the person who has an illegal gun with a fully loaded magazine will be charged with what you call possession simpliciter, or whatever it is, your legal jargon. But if he has 50 rounds with him, in other words, he has 2 magazines, 3 magazines, then he's, in addition to being charged with legal possession, he'll be charged with stockpiling, which carries a different level of a different penalty.
Question relates to the rationale.
That's my understanding.
Senator Motley?
That's what it should be saying now, how it's structured.
The rationale for the quantity selected, is that what you're asking?
No, I'm just trying to understand. Is it clear, Minister, help me, that a prohibited weapon, which, and I'm going to the ammunition part of it, is it clear that it is in respect to an illegal firearm? That's all I'm asking. Is it clear? And where is it made clear? Because where is it made clear?
What the Senator is asking, Minister, and you can help.
Right.
You may be further assisted by Clause 4 as well, which says, unless otherwise specifically provided in this Act, Part 2 shall not apply to any firearm or ammunition regulated under Part 4, and the provisions of Part 4 shall not apply in respect of prohibited weapons. So if there is a license in respect of the firearm, it is covered.
That's clear. That is what
That is where the crux of the scheme is. So there are 2 provisions that you will look out for after we go through the definition section coming up, Member Scott Motley. And that is what is provided for at 3 and then 4. Right. Yes.
I too, I think that adds a little clarification, adds some clarification. However, in 6(1)(b), 50 rounds or more, would it be safer if, because when I read no person shall possess stockpile of weapons, If you said more than 50 rather than 50 or more?
Stockpiling.
Once you get to 50? Okay. So below 50 you're not stockpiling?
So 50 or more is different from more than 50. So so it says...
It turns at 50.
50 or more is where it kicks in. 50 is the threshold. So anything under 50 would not be stockpiling, as provided for. But if you get to 50...
I think the explanation earlier on alleviate my bigger concern,
I think
which is the exemption. Yeah.
The key thing, Member Jackson, Senator Motley, is to keep that there are 2, and the Minister indicated there are 2 regimes, 2 sections of the firearm. There was one time that there should be 2 different bills. The view was that we are better off in one bill, and the section 1 with the prohibited firearms. So all that we are dealing here in this section relates a lot to the prohibited weapons, which is the illegal weapon, as opposed to the regulations which the JR is referring to elsewhere.
Violent.
When it's illegal, there's a breach of the Firearms Act. No, but it's charged differently. In this case, stockpiling is the legal act that can go to prison for many years for. If you are caught with 100 rounds because you bought 50 and you didn't use the first 50, it's a breach of the FLA license. The penalty is different. I think it's a fine of something or they seize it and that kind of thing. Right?
I follow.
That comes on the schedule later on.
We're soon getting to the juice of the matter. Yes. All right. We would want to finish at least part 1 before we break for lunch. Yes.
Property includes real or personal property other than a conveyance. Register means the National Firearms Register established under Section 88. Registrar means the person designated to carry out the functions of registrar under Section 89. Relevant authority means the board or the minister, as the case may be. Restricted person means any person who, A, is a habitual criminal within the meaning of Section 54 of the Criminal Justice Administration Act, or B, has at any time within the period of 5 years immediately preceding the event in relation to which the term is used, 1, been declared to be a restricted person by a court pursuant to Section 55 of this Act or Section 54B of the Criminal Justice Administration Act, or 2, been convicted of an offense involving violence and sentenced therefore to imprisonment for a term not exceeding 3 months. Review panel means the review panel established under Section 87. Security restricted area means a public place declared under Section 50 to be a security restricted area. Signaling apparatus means any flare or flare gun from which smoke or a light canister can be discharged. Slaughtering instrument means a firearm which is specially designed or adapted for the instantaneous slaughter of animals or for the instantaneous stunning of animals. 3D printed firearm means a barreled weapon which discharges or is designed to discharge any shot, bullet, or other missile, and that is mostly produced or manufactured with a 3D printer. Trade in firearms or ammunition means any activity for which a firearms broker's license or firearms dealer's license is required under this Act. The S's on firearms there should be deleted. It should be firearm broker's license or firearm dealer's license.
It's actually corrected, but I think the print came with the errors.
Traffic in relation to any firearm, ammunition, prohibited weapon, or other categories of conventional arms means the import, export, transit, transshipment, brokering, acquisition, sale, delivery, movement or transfer of the firearm, ammunition, prohibited weapon, or other categories of conventional arms, whether within Jamaica or across Jamaica's border. Transferring includes A, letting on hire, B, giving, C, lending, or D, parting with possession. Transit means the movement of firearms, ammunition, or other categories of conventional arms through Jamaica to another country where there is no change in their means of transport while in Jamaica. Transshipment means the movement of firearms, ammunition, or other categories of conventional arms through Jamaica to another country whereby the firearms, ammunition, or other categories of conventional arms are unloaded from one means of transport and reloaded to a different means of transport while in Jamaica. Traveler means any person who arrives in Jamaica as an officer or member of the crew of, a passenger of, or a stowaway upon any vessel or aircraft. United Nations Charter means the Charter of the United Nations done at San Francisco on the 26th day of June 1945, as amended from time to time in conformity with Article 108 of the United Nations Charter. United Nations Security Council means the Security Council constituted under Chapter 5 of the United Nations Charter. Vessel has a meaning assigned to it in Section 2 of the Shipping Act. Clause 3, objects. Whereas the general objective of this Act is to establish a framework which prohibits firearms and ammunition that are illicitly traded and which regards possession of those prohibited firearms and ammunition as the foundation on which other heinous and violent crimes are committed, and to provide, distinct from that framework, a regime for the regulation of firearms and ammunition that are lawfully acquired and duly registered, the particular objects of this Act are to A, eliminate the illegal possession, manufacture, trafficking, proliferation, and use of prohibited weapons, particularly through the provision of appropriate penalties which deter such activities. B, provide for and promote the effective management and regulation of the firearm industry through the establishment of a robust licensing regime. C, establish standards that are in keeping with internationally recognized norms and best practices for the firearm industry. D, regulate the lawful manufacture, trafficking, possession, and use of firearms and ammunition in the interest of personal and public safety.
Madam CPC, just note trafficking is to be deleted because there is no lawful trafficking that takes place. That's on the other end. From B. Right, there's no lawful trafficking at all.
Well, no, it could be because,
Just to point out that the way we would have defined traffic in Clause 2 doesn't suggest that it is just purely illegal. It covers also the lawful movement. So that's why we have lawful trafficking here, to make that distinction.
We'll work that out behind the scene. There's no lawful
Understood.
trafficking of firearms, so we'll have to adjust it. We are
Understanding the way
regulating
trafficking
trafficking.
is
We will
received
regulate other things, but
locally,
not
yes.
trafficking.
You replace the word movement.
Note it and we'll discuss it.
E, align the legal...
With your permission, Mr. Chairman.
Member Williams.
Yes. Just to return to the actual definition of traffic, and specifically movement, the movement or transfer of the firearm. Now, at section 8.1, under possession of prohibited weapon with intent to traffic, it says a person who possesses any prohibited weapon with the intent to traffic the prohibited weapon commits a felony. The definition of traffic here includes movement. No, what specific scenarios are we contemplating on a movement? For example, what comes to my mind? Let's say a person is apprehended on a bus with a firearm in his or her possession, and the police takes it off the person on the bus. Obviously, there is the offense of possession.
That means
implicit.
He's an illegal weapon. He's weapon. Him get charged with everything.
Yes. So he gets charged
possession.
under.
I'm putting the bus punch that is still put on the weapon.
So the person is moved. So in other words, there's the potential of an indictment on two possible offenses. That's what we were saying, possession and trafficking in those circumstances.
And threatening the life of the passenger on the bus. The bus.
So remember the possession is regarded as a foundation on which everything else is done.
Yes.
Right? And usually it's the possession which grounds the offense for the jurisdiction of the gun court.
Yes,
and then you have other things. You can possess it just as a...
Yes, but my concern is if you possess it, obviously you have it in your possession, you're on a bus, you're not necessarily in my...
It's an illegal firearm weapon, you know. This clause, this section only deal with the illegal firearm, you know.
Yes.
So it's a prohibited weapon.
Yes, it's a prohibited weapon. But so you're saying that there is two potential offenses there by just simply sitting on the bus with the firearm in your possession.
There might be more.
You're going into matters of evidence now as to what would amount to traffic possession with intent to traffic.
Yeah.
That will have to be determined on the circumstance of the case.
Yes.
Right.
Yeah, because
If I can charge him with threat to the life of all the people in the bus, and that's a
yeah. So,
aggravated.
well, in terms of, well, probably I'm jumping the gun. Yes.
If you're finished.
Thank you, Chair. Still in the definition section, the 3D printed firearm, which is a term I'd never heard before reading this bill. 3D printed firearm. I wondered how it was different from an imitation firearm, 3D printed firearm. Page 12, under slaughtering instrument.
So remember, based on the definition of an imitation firearm, in comparison to a 3D printed firearm, a 3D printed firearm is an actual firearm. So it has a frame, a barrel, and it can actually fire the ammunition. So it's just the method by which it was manufactured. It's manufactured using a 3D printed 3D printer, which is an actual firearm. I will also bring that out when I come back to the presentation with the different types of firearms.
And I wonder,
This is part of the future proofing of it. 3D printers are not yet easily available in Jamaica, but 3D printers are used to manufacture all kinds of things, including firearms. And therefore, it's reference to the principle. They use to make holes in the day. So the technology is evolving, and it could end up being one of the primary ways of obtaining illegal firearms. So we'll have to bring all. It's particular. It's referred to three-dimensional printing that's really referred to, which will not change in time. But the technology in terms of 3G, 5G, 4G, that aspect will change, but we're not referring to the 5G, 4G transmission of the information. But the printing techniques are three-dimensional, which means it's printing a hole. Actually, you can print your shoes rather than what is currently single-phase printing. We just print a page in color or black and white. Technology is available, you know. It's being used.
Chairman. Just following on that question, the definition of firearm includes a 3D printed firearm. Is there any relevance to the mechanism or the technology used to manufacture the firearm that has any bearing on the offenses that we're creating under here? Because if a firearm is a barreled weapon discharging or designed to discharge a shot, bullet, or other missile, does it really matter whether I made that from sticks and stones or 3D printer? It does what it does. It causes the damage it causes. What's the offense that's related to the method of manufacture?
So we don't make a distinction in the case of the penalty applicable depending on how it is manufactured. We don't make that distinction. We're just making the distinction in the Act, just to recognize that a firearm could be manufactured by a 3D printer. We're just making that distinction there. But in the sense of what is actually applicable in the penalty, we don't make that distinction in the penalties.
So I'm asking the question why, because it would seem to me if we're making a distinction for no reason that it would serve to confuse rather than assist. If a firearm is what a firearm is, a barreled weapon that discharges, then ought the provision to end there. What is the benefit of delineating the method of manufacture, which is what we're doing by saying that it's also a 3D printed firearm? At the end of the day, a 3D printed firearm still shoots, still has a barrel. So why would we include that if we're not doing anything with it?
So it does, and we do agree. This was another provision which we had debated quite a bit internally. Mm-hmm. One of the things that we wanted to do was to really, even for optics reasons, to show that we have thought about how the law is going to be applied in the future. As the Minister would have said before, it's future-proofing the legislation. So we do not want, at the end of the day, someone who come and say, oh, because it's not manufactured in a regular way, it's not really a firearm because it's a 3D printed firearm. The fact is that the 3D printed firearm is a firearm that can cause damage in the same way that a firearm that is manufactured ordinarily will cause damage. So I just wanted to bring it out that 3D printed firearm is also going to be considered a firearm.
Mr. Richards, I hear your response and I do understand it, but that's not, in my view, what we use legislation to do, not to create optics. It must have a purpose to advise the citizen what behavior is permissible, what is not permissible, and what's the penalty for the behavior that's not permissible. Otherwise, we end up with legislation that really does confuse when it gets to the court. So if we are talking about contemplating future technology and wanting to ensure that, it may very well be that future technology creates firearms that don't have barrels. Is that true? So we can't possibly contemplate that, and I don't think the legislation is the place to put that optics in. Certainly it could well be a function of a policy paper laid in the Parliament in the green or white paper, but not in the law. If it doesn't have a purpose, it ought not be here. That's my view on that.
You could note that, Mr. Richards, because I don't think it's as simple as that, Senator, because the 3D firearm, which is made from, non-metallic material largely, and being man can manufacture in the man's bedroom, and I guess prohibited weapon would cover it, but we still have to have it somewhere in legislation because it's not licensed, it's not, technically it could be defined as a toy until you put the firing pin in there. So there's a reason we have to give recognition to 3D manufactured firearm in the legislation. It's a whole new concept, which is operational. It's being used by criminals elsewhere and could reach Jamaica. And there could be technical arguments the same way I argue against it being just in the law. It go to the courtroom and a good lawyer may find a way to eliminate it from the series of definition here. So I think we have to somehow, it may not be the correct way to put it, but we have to recognize 3D firearms, which I said is essentially you download the software on your dining room table and you manufacture a firearm with some wood chip and a spring and a metal firing pin.
But Chair, you have recognized it.
No, it goes beyond. It's not fully. I wouldn't consider that fully recognized as a layperson.
Yeah, but you're not the person who is enforcing this law. The court is.
Yes,
the court is interpreting it.
I can see good reason for not, if it's not defined or recognized somewhere in the law. I'm agreeing that maybe this is not the place to put it, but 3D firearm must be recognized in this legislation.
Well, what would be the purpose of recognizing it if we are not creating a framework about 3D firearms in particular? Because if that is the case, then whatever other technology comes up, you're going to have to amend this law every time there's a technology.
We may have to. But you're getting from the emerging use of communication means to manufacture various things, not only 3D. We'll change the way we approach it. As I said, 30 years ago when we had rifle clubs in schools, now we don't have them. And that was a simple cultural practice. Technology is changing very rapidly. Manufacture ammunition by 3D manufacture, missiles which are not explosives.
So are there things that a 3D printed firearm can do that a normal firearm does not do? Is that the case?
So there are a few issues, Chairman, if I may, before Mr. Richards comes in. So supporting the point raised by Member Harris and also asking if at this point it would be useful to include a section or mention of ghost guns, because to Member Golden's question and point, the issue why people make 3D firearms is A, cost, B, materials used so easier to traffic, and then C, untraceability of the bullet, because it is a ghost gun. So I think because you're trying to deal with the issue associated with ghost guns by dealing with 3D printing, I wonder, especially because it is a term accepted by the UNODC, it may be useful to include at 9.5 or to reorder it to include something there. Just a thought. Or open for consideration. I would love your thoughts on that, Mr. Richards, because I do see where Member Golden is going, because the 3D printing is to create ghost guns. That's kind of the purpose of it. So I just wonder if you want to include that in from definitions and a provision there.
Actually, Minister, that's exactly where I was going, because one of the trends...
Before you answer, sir, based on the explanation that it is created by software, would we not be able to have a definition which makes reference to the software or the technology, rather than just saying like 3D? Because we don't know what next week will bring. And I was just thinking that if the technical team had some time, perhaps they could give us a broader definition, one that is not so restrictive to the particular known type of technology at this point in time, but captures the process. So the emphasis would be on the software-developed firearm. That's what I was thinking.
All right, Chairman, just...
The 3D gun presents, it's worth some interrogation. I don't want to study that. A 3D gun is something if it's used to kill someone, you may be able, well, at this point in time, you will know that they're killed by something like a firearm. But there's no way of identifying it, tracking it anywhere by any means. If even the ballistics won't have any value, the firearm itself can be trafficked very easily because wooden, except for a spring that they put in there. So you keep the spring in your pocket and put it when you want to use it. And the firing pin, it must be recognized in the law. I don't say that. Maybe this is not the right place, but 3D firearms must be recognized in the law because it's a far more dangerous weapon than the manufactured weapon. It's a different weapon. Once a man uses a firearm to kill something, to shoot it, based on the ballistics, I can track it. When I get the firearm, I can use the serial number and track it somewhere. If he uses a firearm as a contract killer, a 3D printer, he has a 3D machine at home, he kills victim number one and throws the firearm down the drain. I find the firearm, I have no way of tracking it anywhere, except I find DNA on it or something, which he will use a plastic gloves to handle so they be no DNA. So that's what it is.
Chair, are you saying that a 3D printed firearm doesn't have a ballistic signature? It has nothing?
No, it has nothing to trace it because it's manufactured from wood chip in your bedroom.
It's sorry?
It's manufactured wood chip on your dining table.
That's why it's called a ghost gun, which is.
But perhaps I don't understand the whole traceability. That's where my darkness is.
Yeah, I know. I appreciate I'm saying it must be integrated on a 3D gun is someone who has the appropriate machine and he downloads the software, which he can do off all kind of sites, and he puts some wood chip essentially, like you're manufacturing cement blocks, and comes out a gun. And all he has to put in there is a bed spring can also be used, just with a high tension spring and a firing pin. And if he shoots someone with it, throw it down the drain and we find it. I have no way of telling where it came from, whether it was imported, manufactured in anywhere. It's literally as my colleague always says, a ghost gun. And he can dismantle and throw it away. And the thing is, because it's so easily done, he can manufacture 3, 4, and 5. So if he's into the business of contract killing, he can contract 1, throw that gun, contract 2, another one, contract 3, or he does this 3 with 1 contract and move to another. It has no element of traceability in there. It's just not, you can't trace it. So it's a whole new operation, I think, which has to be looked at specifically.
But Chairman, my understanding from colleagues is not to exclude the provision of it, but to go a bit wider, to embrace.
No, I hear what you're saying. That's why I'm saying that we have to find a way to account for this new kind of technology. I'm willing to look at if we are satisfied here, because the confusion brought to Senator Golding is, again, whether it was, more should be said in the law so that anybody who reads it can get a clear picture of what we're dealing with and why we do so.
The discussion has raised some other questions. And for those with the knowledge of what the firearm printed by the 3D technology is it a barreled weapon? It is a barreled weapon which is discharged or designed to discharge the shot, bullet, or other missile.
That is correct, Minister, but
right.
You may have to manufacture the barrel separately, but the thing is it still operates as a firearm.
So if that is so, if you take the definition of it on its own, minusing 1, it wouldn't give you a full idea of what we mean by firearm by including the word firearm to define firearm. So if the, just look at it. I've sat in other places where I've had to look on these matters through other lens. All right, so if the intention is to specify including those that are manufactured through the 3D technology, then it would have to be provided for differently. All right?
I think, Minister, you need a...
Right, so there is a problem with the definition as it stands, not above and beyond the questions that arose about specifying the method by which the firearm is manufactured. Because the 3D is one technology that is current, through which this barreled weapon designed to discharge shot, bullet, or other missile comes into being. So we would have to, if you want to signal, so it would be including those created through technology such as the 3D, something to that effect.
All right, so,
all right?
Minister and Senator.
Chair. Something to that effect. But the question as to whether other kinds of technology other than the 3D will create a barreled weapon designed to discharge shot or bullets or other missile is a relevant question, because a statute continues to speak, and you want to take care so you do not limit it. Otherwise, you'd have to be coming back and forth to the Parliament to amend as technology changes. And we try to legislate other than that, unless it's specifically in relation to technology and you're keeping it current. So we will have to look back on the definition.
Minister,
I think the SG wants to come in.
Oh, SG.
Sorry, yes, Chair. I was just pointing out clause 9.3.
Clause 9.3, which reads, well, Minister can go. No person possesses a detailed blueprint or other device for the manufacture of a 3D printed firearm that is a prohibited weapon.
Pointing it out because if you're doing any change to the definition, you have to also look at what is here as well. And you'll notice that 9.3 doesn't speak of the 3D printer. It speaks of or other device, which would include a 3D printer, but...
So I was about to ask SG and Minister and Senator that it's not so much to remove that definition of a 3D printed firearm, but maybe we should broaden it. We should have additional information, additional clause in here to look at what may emerge in due course in terms of any firearm manufactured outside of the normal manufacturing process.
That's the intervention I think Senator Scott Motley was making, Chair, and I agree with you. I agree with her.
We should put something in there, so without removing this clause, we have to broaden it so that when it is ready, we know where we're heading, right? Yeah, because 9.3 will, of course, hold the person who has the printing machine and the software and the technology to transmit it down accountable in a different section, so that's covered there. Thank you, SG.
Actually, for the record, I'd like to thank Mrs. Mesado. A part of the AGC team is not here, but sending messages. We can't all hold.
We have the SG here, that's the whole. Thank you. All right. These 3D firearms are now being made in some parts of it, can be made. It's just the machinery to do it is kind of expensive, but these guys who operate with high large amount of cash may very well begin to look at it.
Chair, might I ask one question on that provision? The definition including a barreled weapon, I'm sorry, goodness, I can't see. Is it that a firearm must come with a barrel, There's no weapon that discharges or designed to discharge a shot, bullet, or other missile that would be considered prohibited under this act? It has to have a barrel for
It has
that?
to be a missile. Weapons ban missiles as well, and if it doesn't have a barrel, it will be a missile.
The simple answer is no, though, because you do have weapons that include the grenades.
Ah.
All right? So if you look on...
Yes.
Right.
Yes, okay. All right, so the firearm must have the barrel. Okay.
So I just want to ask a quick and simple question. When we were looking at what was contained in the definition of ammunition earlier, and we were considering a comment made by the Rifle Association, and we spoke about missile and projectile. I note that in their definition of prohibited weapon, at C you refer to missile, and at D you refer to projectile. And in your definition of ammunition, you only refer to bullet or projectile. So is it that the missile could be included under that?
Two things, either the missile or the projectile, but let's hear. Right.
Well, that is something that we'll take into account, because if I remember correctly, missile would have been included in the definition of ammunition before, and it was removed. It was removed on the understanding that projectile would have covered it. As missile is mentioned under prohibited weapon, I believe it's because it's connected to missile launcher there. It says missile and missile launcher, and then you have paragraph D making reference to projectile as a distinct thing from paragraph C. But it's something that we'll take into account as to whether or not it's necessary to re-include missile in the definition of ammunition, notwithstanding the fact that projectile is there. Yes.
Flagging the definition on two limbs, 1 and 2. One in respect of the missile, A1, and in respect of how the 3D definition, the 3D, that type is provided for. And then we cross-reference it with 9.2, where we have the other reference to the technology to produce printed 3D. So we note that. All right, let's proceed.
3E, align the legal framework in respect of firearms and ammunition with Jamaica's international treaty obligations. 4, applications of parts 2 and 4. Unless otherwise specifically provided in this act, Part 2 shall not apply to any firearms or ammunition regulated under Part 4, and the provisions of Part 4 shall not apply in respect of prohibited weapons.
Thank you, CPC. Chairman, I think this may be a convenient time to take our break to
Look
refresh.
at 1:30. So if I'm
Well,
looking for
I
good
have
time.
some grumbling persons behind me here. And
You hear the
since
grumbling from this
since
episode.
Part 2 is where we will have to spend some time, maybe
I'd
it's
appreciate
just
it.
a convenient
Yeah,
point.
yeah, well, I'm quite comfortable. I was suggesting 1:30, but it's 1:20 anyway. So I will come
Unless
back at.
the refreshments are not ready. If they are ready,
No, if they're ready, yeah, they're ready.
we would take a half hour, 40 minutes break.
Yeah,
Yes, 40 minutes
we'll
max.
come back at 2.
So if we say 40 minutes, let's use 35 and get back in here 5 minutes before so we can settle in.
Back at 2 o'clock.
For this
Yeah.
now.
These next 3
Right.
pages, well, I know Sanders has read documented and to my other colleagues. Up to page 20 is what is going to take us most of the time. I guarantee you, as we did this morning. But this is what essentially is a new part of the bill. Once you get the firearm licensing authority, it's the standard approach. But up to page 20, which we are now at page 14, I would tell you will be
We have exciting things
somewhat
to come, Chairman.
intellectually interesting then.
All right, so
All
we
right,
thank
thank
the
you. So
team.
we'll
for
take a break until
take the-
2 o'clock, all right?
Yes.
And I think okay.
Forests are vital for life on Earth. Mangroves are tropical and subtropical trees and plants that live primarily in coastal environments. Mangroves can be found in every parish. They thrive mostly in the brackish wetlands on the south coast as well as on the north coast. Jamaican mangrove forests are a biologically diverse and productive ecosystem.
They're very important to us as human beings who happen to live near mangroves.
The mangrove is like a wall. We call it a buffer that keeps